Hi guys, welcome back to my channel. My name is Kseniya and I make videos for people who are going through the family immigration process. I'm not an immigration attorney. My videos are based on publicly available information, my own experience, and the experience of my subscribers. And the purpose of my channel is to give you guys the confidence to go through this process completely on your own. There's often a lot of confusion around counting children on the affidavit of support. Specifically, I'm referring to the household size question of the form I-864. The household size question itself often raises a lot of questions, but in today's video, we will specifically talk about which children does the sponsor or the co-sponsor has to count on their affidavit of support in their household size. And as always, if you have any additional questions about the affidavit of support, please check out the playlist dedicated to this form, where you will find the answers to most, if not all, of your questions. According to the Code of Federal Regulations about the affidavit of support, the household size of the sponsor in all cases must include the sponsor's spouse, and all of the sponsor's children as defined by the Immigration and Nationality Act, with certain exceptions, which I will discuss in just a minute. So, according to the Immigration and Nationality Act, children are unmarried persons under the age of 21 who are born in wedlock, which means both the biological parents of these children were married at the time of their birth, stepchildren whose biological parent and step-parent married prior to the stepchild's 18th birthday, children who were adopted before age 16, and children who were born out of wedlock who were legitimized by the or with whom the sponsor has a bona fide parent-child relationship. The only difference between the definition of the child in the Immigration and Nationality Act and the definition of children that must be counted in the affidavit of support is that if the sponsor has a child who is 18 years old and the sponsor doesn't claim them on tax returns as dependents, those children don't have to be counted. So when it comes to counting your biological children, a lot of people don't really have a lot of questions in this regard. However, there is a little bit of confusion when it comes to counting your stepchildren. So the only time a sponsor, I'm referring to both the petitioning sponsors and any joint sponsors. So the only time the sponsor would not count their stepchild in the household size if the stepchild meets all three guidelines. 1. The stepchild does not reside with the sponsor. 2. The stepchild is not claimed on the sponsor's most recent tax return. And 3. The stepchild is not planning to immigrate on the basis of a stepchild-step-parent relationship. For example, a U.S. citizen is filing separate petition for his spouse and stepchildren. As you know, in such case, a U.S. citizen petitioner will have to submit separate affidavit of support for the spouse and each of the sponsored stepchildren. Many times I get asked, should the stepchildren be counted in the spouse's affidavit of support, even if they're still overseas? By definition discussed earlier in this video, yes, these stepchildren don't meet all three of the criteria we just talked about. Indeed, they do not yet reside with the sponsor, and the petitioning sponsor doesn't yet claim them on his most recent tax returns. However, because these stepchildren are planning to immigrate on the basis of their stepchild-step-parent relationship, they do have to be counted. What about, for example, counting stepchildren from previous marriages? The sponsor or petitioner does not have to count these stepchildren once the stepchild-step-parent relationship is dissolved through divorce, unless the stepchild in question is still claimed as a dependent on the sponsor's most recent tax returns. When it comes to children that are born out of wedlock, things can get somewhat complicated. And in most cases, if you do know that this is your child, or perhaps you are listed as their parent on the child's birth certificate, or perhaps as their biological parent, you also pay child support, Even if this child doesn't actually reside with you in your house, you do still have to count them as your child. But a general rule of thumb is USCIS is not going to penalize you for counting more children than miscounting or undercounting children. I hope that you found this video useful. Again, if you have any additional questions about this specific form, I recommend that you check out the playlist that I will also link in the description box of this video. Good luck in your process. Subscribe to this channel if you haven't already. Give this video a thumbs up, and I hope to see you guys in my next videos. Bye!